am going to stop sharing my screen and ask our panel members, Evan Farr and Elena Sallitto, to come on screen and let's get to know them better. There we go, Evan and Elena. Well, first off, welcome you two. I'm thrilled to kick this off with you two. So
Thank you
uh,
for having us, Steve.
let's get started. And for the audience, I'd like to kind of break these discussions into 3 rounds. Round one is let's get to know our panel members. Round two is our panel members sort of sharing some insights and tips and things that they're seeing in the marketplace. And round three, you guys in the audience, you're driving round three. We're going to try to tackle as many as your questions and challenges and comments as we possibly can. So let's first get to know our attorneys here. So Elena, you know the old saying, "Ladies go first." I'm gonna start with you. Tell us a little bit about yourself. What led you to practice law, and then what led you to specialize in elder law?
Thank you, Steve. I appreciate it. I actually have been a lawyer for forever, for a very, very long time. And elder law is my second or third career, I guess. My first career was as a trade regulation lawyer doing antitrust and consumer protection. And then career number two was I stepped back to raise my family, take care of my kids. And around the same time that I was thinking about going back to work, my parents became ill. I'm an only child, or was an only child. And so I started to take care of them around the same time that I was going back to work. And it all kind of evolved. I learned a lot from dealing with them. I was a long distance caregiver. I wish I had known then what I know now. I would have done things a lot differently. But there you go. And I've just been practicing in elder law exclusively since about 2008.
Great. And your practice name is?
Stavely and Sallitto Elder Law. I'm a certified elder law attorney. We are national, Evan is also, we are nationally certified through a foundation. Catherine and Stavely, my partner, has been doing this for over 20 years. So between the two of us, we've got more years of experience than I care to admit to. So
Great.
I'm just going to let it go with that.
And do you, what geographic areas do you primarily serve?
We're in Maryland, and we really focus primarily in Anne Arundel County and the surrounding counties.
Great, great.
We do a lot of hands-on, we do visits, home visits, that kind of thing.
Excellent. Well, we'll definitely get back to you, but let's get to know our next attorney on the panel, Evan Farr. So Evan, same thing. Tell us, what led you to law, and then what led you to elder law?
Yeah, thanks, Steve. So actually, ever since high school, taking a legal class at the local law school, and then founding the law club in high school. I always wanted to be a lawyer. Started in practice as doing estate planning and general practice, and I did that for the first 14 years. But mostly estate planning. Always, at least 50% of my practice was estate planning. And at the end after about 10 years of doing estate planning, it started to dawn on me that I was not serving my clients completely enough and well enough, because more and more of them were aging or had aging parents. And I was not able to answer basic questions for them about elder law and Medicaid and how do we plan for long-term care, and does a revocable trust protect your assets if you wind up in a nursing home, and just, really basic questions that deserve to be answered. And I got sick of telling people, well, I'm really not sure because that's an elder law issue and I don't do that. So I decided I need to do that. So I took several years to study elder law with the top attorneys around the country. And this was like 18 years ago now. Been practicing over 30 years, and became a certified elder law attorney. That one thing Elena didn't mention is there are only about 500 of us in the entire country. And that's because a big part of what we do is Medicaid and Medicaid planning and life care planning, which we'll talk more about. But because Medicaid is such a critical piece of elder law, and because Medicaid is the most complex area of law in existence, that's why there's so few of us. To become certified, as Elena and I have done, it's a 5-year process. Then you have to take a full day certification bar exam, which has like a 20 to 25% pass rate. So it's just unbelievably complex. So my firm, we've grown over the years. We have, I think, 16 or 17 employees now. We have 4 lawyers. One other is a certified elder law attorney. 2 that do estate planning and estate administration. A lot of paralegals. Our main office is in Fairfax City. We also have an office down in Fredericksburg, Virginia, and we have an office in DC and in Rockville, where I'm licensed, and 2 of my other attorneys are licensed in all 3 jurisdictions. And we serve clients throughout the entire Northern Virginia, well, even all over Virginia, really, because of our Fredericksburg office, and all over DC and Maryland, mostly Montgomery County, but we do Prince George's and
Great.
other counties close in as well.
Excellent. No, well, this is great. And Evan, you touched on some of the certification. Before we kind of jump into the hot topics and the things that I'd love for you to share with the audience, can either one or both of you sort of just give us the broad definition of what an elder law attorney is? And I think sometimes, like when I'm at a barbecue or a cocktail party, there's the general public is often sort of like, when I bring up elder law, they're like, oh, like, I've got an estate planning attorney. Is there a difference? And if so, what are they?
When I explain the difference, what I usually say is estate planning attorneys are interested in your stuff after you die. They want to make sure that your heirs and your beneficiaries are taken care of, and they look to maximize your assets for that purpose. Elder law attorneys look more on that latter part of life before you die, to make sure that your assets are best utilized for your comfort and care. So we maximize the client, the elder person, their well-being. And we don't worry so much about the heirs down the road. It's there's mom and dad's money, and it's for mom and dad's comfort. If there's anything left, then we take care of them. I don't know, Evan, you might want to add something to that.
No, I completely agree, Elena. Elder law, estate planning is a big part of elder law. We elder law attorneys do estate planning. As I said, that's my background before getting into elder law. I'm the same with most elder law attorneys. But we've sort of seen the light and realized that leaving an inheritance is not the end all and be all. In fact, most of our clients, the kids are better off financially than they are, and they're not worried about leaving an inheritance. Elder law is about protecting the dignity and quality of life of the elders as they age, whether it's aging in place, and we help them through that, and finding sources to help pay for them to age in place or to move into assisted living. We help them get veterans aid and attendance benefits to help pay for home care and assisted living. And then we help get Medicaid to help pay for nursing home care. And in Virginia and DC, at least, Medicaid will also pay for in-home care. Sadly, not in Maryland, but
Not so much.
a lot of Medicaid in Virginia and DC.
Yeah, I think a lot of what we do, what's driven is the shock that people have when they realize how expensive long-term care is, how little government assistance that there is to cover it, and that insurance doesn't cover long-term care, and all of a sudden they realize, I need assistance, I need additional help, and they're looking at thousands of dollars a month, which is prohibitive for a lot of people.
Great.
Right.
Well, This is awesome. And okay, so we finished round one. So round two, we got questions that are coming in, but before we jump on those, I'd love to sort of hear your guys' thoughts. And Elena, you actually inspired an article in the new source book that is going to be coming out. The Maryland edition is going to be coming out later in a week or so, on some Medicaid nursing home topics. Maybe if you sort of share some of that with our audience, and they can obviously follow up and see the article here in a few weeks.
Yeah, and what precipitated that was a lot of frustration on my part, because I'm seeing so many people get hurt because there's so much misinformation about Medicaid and what the program is and what are the protections, or if there are protections. And people, at least in Maryland, this is where I'm coming from. People are under the impression that they have to absolutely impoverish themselves in order to get long-term care benefits in a nursing. Well, in Maryland, it's in a nursing home, when in fact, the whole Medicaid program, the whole statutory scheme is put there to protect people from utter impoverishment. So it enables the, let's say, the community spouse, or there are certain family members that are still at home. They can protect and preserve those assets for their benefit. And even if you have a single applicant, there are ways to preserve those assets to enhance the quality of the person's life in the institution. Some, people don't necessarily realize that Medicaid covers really just bare bones of what you need. So if the person's in the institution, they need dental care, they need maybe custom fitted hearing aids, which are very nice to have, or something as simple as an Alexa, which is technology, new technology that gives us so much, or a grandpad, or a cell phone, or something to keep communication going, especially in COVID days. So there are lots of reasons to kind of protect your assets, both for the comfort of the spouse that's still at home. You want to make sure that that person's protected, and to enhance the quality of life of the person in the institution. And that's what the Medicaid laws are designed to do, to avoid having to put you down to absolute destitution, so the government will step in and give you a bare bones existence. That's in a real nutshell.
Awesome. No, great sort of topic to throw out there. Evan, how about you? What's on your mind, and what are you seeing with your clients, or any words of wisdom that you'd like to share with the audience?
Sure. Well, to elaborate on something Elena said, the general rule is that, and this is important for all of you senior serving professionals that are on the call today, the general rule is for a married couple where one spouse is in the nursing home, or if it's Virginia or DC, in home but in need of the nursing home level of care, we can protect 100% of the assets for the healthy spouse and get the medically needy spouse on Medicaid. And again, it's either a nursing home, or in Virginia and DC, it's up to 16 hours a day of in-home care. And for a single person, we can generally protect 40 to 70% of their assets, and sometimes 100%. And this is in crisis mode. This is when they're coming to us, even though I haven't done pre-planning, they're coming to us at the last minute because someone's in the nursing home and they realize, oh my God, it's $12,000 to $14,000 a month. Mom or dad's going to go broke. And what can we do? And that's often when people come to us. Now, I also do Medicaid pre-planning using a special type of asset protection trust called the Living Trust Plus, which protects assets. It's a 5-year Medicaid trust, but it's more than that, because it protects assets from probate, plus lawsuits, plus veterans benefits after 3 years for qualified veterans, plus Medicaid after 5 years. And we use this trust in all 3 jurisdictions. And I actually license it to attorneys all over the country. We have about 60 throughout the country that do this. If any of you folks have, friends or family members in other parts of the country looking for this type of Medicaid asset protection trust, feel free to go to livingtrustplus.com and you can find attorneys that offer that. The following up on one other thing Elena said, she mentioned that insurance doesn't cover long-term care. And of course, she meant health insurance. And that is critical for everyone to understand. I'm sure almost all of our attendees understand it because they're senior serving professionals. But I saw there were some attendees who are caregivers for their parents, and they may not realize that health insurance, or including Medicare, which is the biggest health insurance provider for people over 65, does not cover long-term care, not one penny, not ever. And that's where we elder law attorneys come in, is to level the playing field, to help people not get taken by the system and have to spend all their money and go broke, because in large part, our health insurance system essentially discriminates against people who get the wrong type of illness. And this is crucial to understand, why it's so important for clients to do Medicaid planning and work with an elder law attorney, because health insurance discriminates. If I always give the example when I do my monthly webinars of, two people, John and Joe, and John has a brain tumor, Joe has Alzheimer's. Well, what do they have? They both have things in their brains that aren't supposed to be there. But because John has a brain tumor, his health insurance, Medicare, his secondary health insurance, they're going to pay for everything: chemotherapy, radiation, surgery. They're going to pay for it all over again if the cancer comes back or spreads to another part of the body. Health insurance will spend millions of dollars to treat this brain cancer, even if it only gives John an extra year or two of life. But we look at Joe, who's got plaques and tangles in his brain. The doctors throw up their hands and say, oh, well, there's nothing we can do about that. Sorry, Joe. The care you need because of the disease you have is going to be long-term care, starting at home, probably going into assisted living and memory care, and eventually nursing home care. And sorry, Joe, you and your family have to go broke. And in some states, including Virginia, even your children may have to go broke paying for your care unless you get Medicaid. And that's where Medicaid is so critical for people to get. And they do that by working with elder law attorneys and protecting assets so they don't have to go broke.
Yeah, no, that's very well said. And I don't know if I've heard it that way. Elena, any additional thoughts on this topic? And then we can start jumping into questions so that we can get finished at a reasonable time, because I see they're flowing in for you guys.
The only thing I'd want to add is that it's really never too late to plan. And even if you're already in the nursing facility, and even if the nursing home has filed an application for you, my experience has been that there's turnover in the business offices, and that the planning is so complicated, and nursing homes are not in a position of providing financial advice to help a family through. But even if you're at that stage, still at least get a consult with an elder law attorney, because there may still be a way for you to protect and preserve the assets. So that's really all I wanted to say.
No, this is great. Well, let's jump into some of these questions. They look really good. And as I had mentioned, just because we had two people email us with questions before this event even started, I want to make sure that we honor that initiative. Okay, so the first one was from Carol Augustine, and it's the step-up provision for inheritances, as well as real estate inclusion for sellers, may be eliminated. This will adversely affect elderly who have a will and have lived in their homes for 50 years. If you sell your home, Medicare Part B and D premiums will increase. Are there any strategies to lessen this impact? That's because I'm not there. I don't really understand that, but can you give somebody like Carol some feedback?
So for people to understand, if property passes by will, then you get what's called a stepped up basis in the cost of the house, or the cost of whatever the asset is. So you get the value as of the date of death. And so if you then sell the property and there's any capital gains, it's only going to be the gain from the date of death forward. What they're talking about now doing, and it's a tax increase, is eliminating that stepped up basis, so that if you inherit, you're going to take the basis of the decedent. So whatever the cost of the asset was when they purchased it to where you got it now, you're going to take their basis. So if, let's say, they bought the house for $45,000 20 or 30 years ago, and now it's worth 400, your basis is no longer going to be 400. It's going to be their 40,000. It's controversial. They're talking about maybe phasing it in, phasing it out. So it may not be that big of a deal, hopefully, for people below a certain asset level. So we're going to we're going to breathe easy. We're not going to get upset about it yet. In terms of the income affecting the sale of the house, affecting the premiums, Evan, please correct me. My understanding, because I may be misreading this, but your premiums are based on your income for the 2 years prior to the date that Medicare is assessing your premiums. When you go to sell your house, the government lets you keep $250,000 per owner in capital gains tax free. So it shouldn't really affect your income when you sell the house. And if you do have some kind of aberration where you do have a huge income because of a massive amount of equity, and they say, okay, because 2 years ago you made all this money because you sold your house, there is an appeal process that you can tell them, sorry, that was an aberration. This is not my normal income, and kind of get them to back off that way.
Yeah,
Great.
so let me just add a few things. And Elena mentioned the current step up in basis is for property passing through a will, but not just through a will. It's for any property
Yeah.
passing on death through a will, through a trust, through intestacy, even through an irrevocable grantor trust like the Living Trust Plus Asset Protection Trust that I mentioned earlier. That still provides the step up. Now, if they do away with the step up in basis, number one, yeah, that's going to suck for a lot of our clients. But often, so hopefully it doesn't happen. They've talked about this for years. Hopefully it's not going to happen. If it does, what often happens with the law, as in so many areas of life, when one door closes, another door opens. So we don't know what else is going to happen, but this, there may be something else that helps our clients get around that. One tool that currently gets around that, it's not for everybody, of course, but there are charitable trusts that we use for some clients. Most common is a charitable remainder trust, where if you give your house or any other appreciated asset which has a lot of potential capital gains built up, you give that to a charity. Number one, you get an immediate income tax deduction because of your charitable donation, which can be spread out potentially over 5 years if need be. But then what happens is the charity, because they're a charity, when they sell the property, they don't have to pay capital gains tax. So you're avoiding the capital gains tax. And then the charity, if it's a charitable remainder trust, what that means is that the charity, through a trustee, is going to pay you a stream of income, typically for the rest of your life. It might be for 20 years. Typically it's for lifetime. It might even be for your lifetime and for the lifetime of your spouse and even the lifetime of a child. So you can stretch out that income stream. Again, doesn't work for everybody, but it is one current way we have around capital gains for people who have, more than 250 or 500,000 growth in their home, which we do have some of that around here. And yeah, as far as the IRMA, the income related to the increasing the Medicaid or Medicare premium. Yeah, that's if you're using the exemption, the 250 or 500,000 exemption, you're probably going to avoid IRMA. But if they do away with that exemption, yeah, we're going to have a lot more people having IRMA. And I actually learned something here from Elena, because I wasn't familiar with there being an appeal process for that. So that's
Yeah.
great to learn.
This is one of the, thanks guys, great feedback. There's a couple of things here. This happened on our aging life care discussion. It's sort of like, it's great when you can sort of bring people from a profession together, sort of chatting, because the panel members are sort of getting real-time feedback. And one of the things, based on the questions and based on your responses, is you got to have your eye on the ball in terms of what's going on in public policy and Medicare, Medicaid changes, especially in a year where we got changing administrations. I guess the do-it-yourself elder law and estate planning is, there's a lot of things that you're leaving up for chance when you try to do that.
There really is no such thing as do-it-yourself elder law.
Yeah. Well,
Yeah,
I know a lot of people try to do it, because we hear from our readers about the chaos when mom is not doing so well. Okay, our next question, and I think as Evan had mentioned, a lot of people in the audience are providers in the world of senior living, but as you're going to see from some of these questions that we're fielding, we have a lot of older adults and family members too. But for the providers out there, John McCarty is starting a new company, Cardinal Transition Services, who he feels is, local elder law attorneys are going to be an ideal referral source. And I'd love for you guys to pull back the curtain for all those providers that are out there that are trying to network with elder law attorneys on some, helpful tips on what the best way is just to communicate with you two, and what types of organizations do you all refer to?
Sure. Well, to get in touch with me, I just put my contact phone number and website in the chat, so folks can get in contact with me there. We refer to all types of senior serving professionals. I have a whole page on my website devoted to trusted referrals to other senior serving professionals. I think we have every category of senior serving professionals covered. I always welcome adding new people that I trust to my website and referral sources. Personally, what I love getting to give to clients, well, at least pre-COVID, was the trifold brochures, because it's easy to keep those stands sitting in our office. We can keep lots of them from different providers, and to keep us restocked with them, send us another batch of, say, 20 every year, especially if you change your trifold brochure. But that's what we like. Is
Okay, great.
Now, of course, with the pandemic, we're seeing very few people in the office. We still do see some, so it's more about maybe setting up a Zoom chat, a virtual coffee, so to speak, to chat for 10 or 15 minutes, and if it makes sense, then we would add your information to our trusted referrals page.
Great. Excellent. Elena, any words of wisdom for those referral sources out there?
Pretty much I'll echo what Evan says. We do deal a lot with different professionals, and anything that I can use to give out to clients, because I will have clients ask me about certain types of people, and it's great to be able to hand out and say, here, talk to this person. So anything like that is helpful.
Great. Cool. Okay, let's jump into the questions that have come in here. And Steve Jeffries says, Elena, in your intro, you mentioned, "I wish I knew then what I know now." Can you give some examples of some of those?
Um, yeah, just personal experience. I have been pushing back against health care providers that keep saying, okay, it's now time to take this person home, or it's now time to do this. Really pushing against pushing decisions that really don't need to be made right away. So that's number one for me.
Okay, great. Yeah, people feel a lot of pressure, especially
Yeah.
when they're in the hospital. And I think d- as elder law attorneys, if somebody is working with you, you can be a sounding board and an advocate for them, I'm
Yes.
assuming.
Most people don't realize they can say no.
Mhm.
If they feel like they have to listen to what the doctor says or what the provider says, they say, "Oh, now it's time to do this." No, not necessarily. Just because the doctor wants it doesn't mean you have to do it. So,
Great.
Yeah, that's
Um,
a big part of our advocacy,
yeah,
helping teach our clients, yeah, that they don't have to just go along with what a hospital or nursing home is saying.
mhm.
Good. Okay, and Steve has a question for you too, Evan. You mentioned life care planning. What does that cover?
Yeah, so life care planning is the general umbrella term for the type of elder law that Elena and I were both talking about, which is focused on helping the family navigate the care needs of the elder, getting them the best possible care, helping them pay best for that care by not having to go broke and tapping into other benefits like veterans aid and attendance and uh, and Medicaid to help pay for their care. But the focus of life care planning is on planning for those the aging years of the elder. And yes, asset protection is a part of that. Maybe protecting an inheritance is a part of that, but it's typically not the focus. Whereas in the earlier days of elder law, and there are still some elder law attorneys whose focus when they do Medicaid planning is all about protecting the inheritance. And so life care planning is kind of not the opposite of that, but just much broader in that our focus is on the elder and preserving the dignity and quality of life. And yeah, maybe an inheritance, that's a nice afterthought if that happens, but that's not the
What's the
focus.
bumper sticker? I'm spending my kid's inheritance. I think
Exactly.
that's
And that's
most children's dreams, is that that's what we want for our parents.
exactly.
Let's see. Isabel, we've received several questions about this, and I know it's a moving target, but Isabel says, how do you charge your clients? For example, do you have a sliding scale if clients are not wealthy? And I guess, are there some elder law, I guess, how does legal aid work and things like that? But how do you all charge, and the world of legal guidance for older adults? How does that work in terms of a cost basis?
Well, so in our office, we have what we call 4 different levels of planning, and each level is increasingly more work and more expensive. Our level 1 is incapacity planning, which is just powers of attorney and medical directives. And level 2 adds a revocable trust to avoid probate. Level 3 adds this living trust plus I mentioned to protect the assets from probate, plus lawsuits, plus veterans benefits, plus Medicaid. And then level 4 is the life care planning, the crisis planning. Um, so levels 1 through 3 for us, those are flat fees, very reasonable for most people. Level 4, we do offer a sliding scale. It's based very much on the amount of assets that the clients have and the amount of work we perceive. Our fees range anywhere from typically about 10,000 for the level 4 planning, from about 10,000 up to 25,000, sometimes even more for that level 4 life care planning. And there's an initial retainer fee, and then we have an annual retainer fee to keep us on retainer.
Great.
Legal aid, there are some, at least in Northern Virginia, that I'm most familiar with the legal aid program. They do have an elder law department of legal services of Northern Virginia. They've gone through periods where they don't have someone who does elder law and where they do. So I don't know at any given time if they have someone who does that, but we do sometimes refer to them. You know, if someone truly just has no money and they just want help applying for Medicaid or getting a guardianship, sometimes legal services can help with that.
Great. Elena, thoughts on that? Is your practice similar, or do you have any sort of differences in terms of charging?
I think a little bit, yeah, so some differences in how we charge, but yes and no. I think everybody kind of does the same kind of thing. You know, you look at the complexity of it, you look at exactly what's involved, and then you kind of take it from there. Definitely a sliding scale in terms of the amount of the resources that we're looking at and how difficult they are. For, you know, a lot of the documents are, the estate planning is done very much flat fee. But when you get into Medicaid planning, you know, you've got the 5-year look back, and that's where the state looks at every transaction of every financial statement you have for a 5-year period. And if you have 20 different accounts that have been you know, closed and opened and closed and opened, and we have to trace all that, you know, that's going to be one charge. Whereas opposed if you have like a couple of accounts and you really haven't done much, and it's going to take not much time to go through and do that tracking and tracing, it's a much less fee, lower fee.
You know, a good
I
question.
don't know if that helped or not.
Oh, no, I think it did. And this is great. And a good question. And I'm seeing a variety of sort of questions and comments in chat and Q&A regarding affordability. Like, is there sort of could it be boiled down to net worth or income or otherwise, where like when you receive a call from somebody, it's sort of like, okay, you know, based on the amount of assets or what you're trying to protect, it's not necessarily cost effective to work with an elder law attorney. Here's the path that you take.
It's always cost effective to work with an elder law attorney, even if you don't hire them to do the whole process. For example, we met with someone yesterday, and this person was eligible from the get-go, didn't realize it, but had some minor issues. So we sat down with her, and for, you know, the one consult fee, she's all set, and she knows exactly what she needs to do and how she needs to go. But we're not going to get involved in that. But, you know, somebody who has to, where we do the, I know Evan and I have terminology differences. I call it the spend down. He calls it the asset protection. I like his phrasing better. But if you're going to go through a complicated asset protection and you're with them for a year, because we also do post-eligibility planning for estate planning to make sure that the Medicaid person stays protected. And then we also include the first redetermination in what we do. So we kind of wrap everything up in a ribbon. That's going to be much more expensive than, you know, just the hour. But it's always a good idea to just at least sit down with an elder law attorney to see where you can save and what makes the most sense for your plan.
Right. I know that's, since I've been doing this for 30 years, that's always a question. So I'm glad to sort of hear that explanation. That's great. Marcia Earhart says, if one lives with children, whether in home or in an in-law suite or apartment, and you need long-term care, would the children have any responsibility to pay?
Not in Maryland.
Yeah.
Go ahead, Evan.
And not in DC, but yes, in Virginia. So Virginia is one of, I think, 32 or 35 states that has filial responsibility, which law says that if a parent goes broke and they still need long-term care, that the children can be forced to pay for that long-term care or medical care. I have, if you search my website for the term filial responsibility, and that's FILIAL, you'll find many articles we've written on it, including one page that lists all the states where filial responsibility is still alive and well. And that's a real concern. But again, if you get in that situation, if the child helps get the parent on Medicaid, that stops the filial responsibility obligation dead in its tracks, which is a very important reason that doing Medicaid planning is so important.
Wow. Yeah. And yeah, again, that I definitely learned something here on this call, that here we are in the DMV and one of the states has the, so really good there. Okay. Uh, an attendee says, I have an unusual circumstance. I'm a caregiver and power of attorney for a 95-year-old cousin and was living in her house. She's now in assisted living and I'm in her house and I have been here for 15 years. Will I have to sell her house when she runs out of money for assisted living?
What state is she in?
She didn't indicate. So if you can, and she's anonymous. So the anonymous attendee, if you want to elaborate on the state, but in general, what's your guidance for?
So this is where the laws of the three jurisdictions are quite different.
Oh, she's in Virginia.
Okay, so in Virginia, but maybe I'll answer for all three states since I practice in all three. So in Virginia, the answer is yes. She's going to have to sell the house because unless we protect it, and there are ways to protect it, potentially, although it's difficult in the current market environment because it's such a seller's market. But in Virginia, the house is only an exempt asset for 6 months after someone goes into a nursing home, or as long as they're living in the home. After that, in Virginia, you have to sell the house unless we protect it using various strategies. And then the money has to be protected. And if it's a single person, again, once the house is sold, we can protect 40 to 70% of the proceeds from the sale, sometimes 100%, and get them back on Medicaid. Now, the answer is very different in DC and Maryland because, well, in Maryland, the home is completely exempt forever, as long as somebody signs an intent that they're going to go home, as fictitious as that may be. Now that doesn't mean the house is protected, because Medicaid is either going to put a lien on it during the lifetime, or they're going to come back after death and get the house through what's called Medicaid estate recovery, which exists in all three jurisdictions, in all 50 states for that matter. DC is very similar. Now, technically, DC in the regulations has the same 6-month exemption as Virginia, where the house is only exempt for 6 months. But in reality, in practice, DC exempts the house forever, like they do in Maryland. And so in DC and Maryland, the goal of protecting the house is about protecting it from estate recovery, not so much protecting it in connection with eligibility.
Great.
I want to add one thing because we were talking about somebody in an assisted living facility, and in Maryland, Medicaid wouldn't be available to cover assisted living. It's only available for the nursing home. So
same with Virginia and DC.
Yeah, and what a frustrating aspect of that that program. Hopefully someday it can be expanded. Let's see. I think this might be the same person. Where is the best place to keep your will, trust, and other estate papers? We have heard that safety deposit box at the bank is not a good place.
They're kind of going out of business.
Uh-oh. Oh no.
Is more valuable then and so most banks don't, new banks aren't having safe deposit boxes. But we tell most people keep them in a fireproof safe of some sort in your home. Some attorneys send wills to the court to be held for safekeeping. We don't believe in that in our office because people change their wills so often. And if they move to another county or another state, it becomes difficult to get the documents back. But I don't know, how do you handle that, Elena?
Pretty much the same way. We tell them just keep it in a safe place, let people know where it is. And if they want to file it with the Register of Wills, it's a $5 charge, you know where it is. But if you want to change it, the testator has to retrieve the will from the register. They won't release it to anyone else. So it can be a little cumbersome if you want to change the will down the road.
Right.
And the court won't keep trusts or power of attorneys and those.
No.
Well, you can record a power of attorney in land records. But then again, if you change it, you got to re-record a new one. So not always a good idea.
Let's see. Jan Buchanan asks, can you both speak to long-term care insurance and where it's going? Premiums are so expensive, benefits limited. Most middle-income folks can't afford it. Where is the affordability of LTC going?
I'm happy to talk about that. I'm actually licensed to sell long-term care insurance and hybrid long-term care coverage, as well as other insurance products and financial products as well. But I'm a strong believer in people having long-term care insurance. I love it when clients have it because of what we just talked about a minute ago, and that's the fact that Medicaid doesn't pay for assisted living, whether that's assisted living in the home or in a facility. But long-term care insurance does pay for that assisted living. And most people who have dementia, for instance, they're going to go through this aging continuum where they need in-home care and then they need assisted living, maybe for 5 years or more before they ever need nursing home care. And we can help them with the Medicaid and the nursing home, but they need long-term care insurance also to cover the home care and the assisted living. The questioner is right, of course, that traditional long-term care insurance is a dying industry. It's a bad business model, which is why it's a dying industry. Premiums are skyrocketing. They go up almost every year with most of these companies. There used to be like 100 companies offering traditional long-term care insurance. This is where you pay every month. And then when you go on a claim, you stop paying and you have a period of years of coverage or a pool of money of coverage with a daily amount. And those, now it's down to about a dozen companies that offer these policies. Most have gotten out of the business. A lot of claims get denied, and but it's great to have when it's needed. But there are the newer breed of long-term care insurance, and what most people are getting these days is hybrid long-term care insurance, where it's not the traditional use it or lose it health insurance model of long-term care insurance. Instead, it's based on a life insurance model. So it's typically a combination of a life insurance policy or an annuity combined with a long-term care insurance rider or coverage. So if you don't use your benefit to pay for long-term care, then the money you've paid in is there to fund a death benefit for your spouse or your children. So it's not a use it or lose it. And with this life insurance based model, if you do, sometimes people pay a one-time premium. That's where you get the best bang for the buck, is paying a lump sum for it. Or you can pay it over 10 years. It's still, you get pretty good bang for your buck. The least cost effective is when you pay the monthly premium, but you can still do that with these hybrid policies. You're not going to get nearly as good a benefit, but it's still affordable for a lot of people, and it's not going to be a use it or lose it type of scenario.
Great. Okay. We got a few more questions we got to get through here, and we're getting close to the top of the hour. Are you guys okay if we stay just a little bit beyond 1 today?
I'm fine.
Yeah, I'm good.
Okay, great. Okay, so pour over will, pour over clause. Can you explain these? Is a trust created after death so a state does not have to be challenged by probate process and the expense of probate and time and money? Can you explain will-based estate plan and trust-based estate planning? Thank you for so much in being able to guide family members on this complicated area of life. Again, I don't understand this, but I can't wait to hear you guys explain it.
I'll do a real quick, and then Evan, you can, yeah, they're both ways to transfer your assets at death, both of them. So a trust is very often considered a will substitute, and there are reasons to have one or the other. And sometimes there isn't a reason to have one over the other. A trust is very handy for control and administration of assets, especially if you've got complicated assets, or if you just want to avoid probate and you want to keep everything private. The will is going to need to go, it gets filed with the court. Everything, the accounting goes through the court. You have to open an estate account. You have to file probate fees. There's all that. So it's much more public administration, if you will. You can set up trusts in your will, testamentary trusts, which is a totally different thing. So it's a very complicated question, I think, to answer in a short period of time. So Evan, you might be able to do a much better job than I just did.
Well, you did great, Elena. I would just add, part of the question, I think, started with what is a pour over will?
Yeah.
So when you do a trust, whether that's a revocable living trust or the living trust plus, which is the irrevocable asset protection trust that I mentioned, you typically have, not typically, always have with that a pour over will, which in part, the main part of the pour over, what that simply means is if there are any assets that were titled outside of the trust that didn't get transferred into the trust for whatever reason, either you forgot, you never got around to it, maybe you died before they got funded, or you after acquired the asset and didn't, just forgot you had a trust, those assets will go through the will and pour after probate, after this nightmare of probate that Elena was mentioning with annual accountings and all that, which is time consuming, complex, and expensive. So we don't want things to go through the pour over will, because that means they have to go through probate. But the pour over just means that after it's done with probate, it's going to pour into the trust. So the trust is the beneficiary, the sole beneficiary of the pour over will, so that the trust becomes the tool that then distributes the assets to your children, or better yet, clients. The way we generally draft our trust is they will continue on for the lifetime of each child and provide ongoing lifetime asset protection for each of your children or other beneficiaries, so that the money your children inherit from you is protected from divorce and lawsuits and bankruptcies and medical bills and all of life's risks.
Great. Okay, let's see. Ellen Pincus was just clarifying. Elena, you practice in Maryland, and then Evan, you're in DC, Maryland, and Virginia, correct?
Correct.
Okay. All right. Sarah Tim says, I thought that once someone went into assisted living in Maryland, the intent to return home was severed and the house was counted.
She's right.
Oh, okay. And then let's see, somebody said they're going to be reaching
I'm
out to you
confused about
guys.
that.
Evan looks quizzical. Once you, yeah, you can't, there's no intent to return. Once you go into assisted living in Maryland, then you can no longer protect the primary residence. It's not considered your primary residence. The primary residence becomes the assisted living facility. And
But
so if
then-
you go to a nursing home from the ALF, you can't protect the home that you left.
Okay.
See, I love these discussions. It's sort of, yeah, it's,
And there's
okay,
something- I guess we've always had people go directly from the home into
Yeah.
nursing home.
Yeah.
no, I
And-
Or
mean,
you
it's
have this, or you have the spouse in the nursing, the spouse at home. You can have the spouse at home, one in the assisted living facility, and then they transfer to the nursing home.
let's see, this is a good one because we're talking about long-term care insurance and I'd be curious about this is, does any of what you said today apply differently or not at all to CCRCs and life plan communities? Like if somebody is looking at that as an option.
Yes and no. So a lot of when we do our Living Trust Plus, a lot of the people doing that are doing that because they're thinking of going into a CCRC life plan community, and they don't want to, maybe they've got $2 million in assets, and the life care community, their entrance deposit is going to be 400,000, and the facility wants them, assuming their income's good income, the facility maybe wants them to have another $100,000 or $200,000 of assets. So the facility, to admit them, is going to be looking for them to have about 600,000, but they've got 2 million. Well, if they disclose the entire 2 million to the life care community, the life care community is basically going to put a lock on that money and say, you can never give that away. We want you to spend that in our community. But if they put the excess money, in this example, the 1.4 million, into the Living Trust Plus to protect it, then when they apply to the community, they're only going to list that they have 600,000 in assets. They're still going to get in because they're qualified, but now they're not letting the life care community dig its claws into all of that additional 1.4 million that they have. Instead, they're, in this case, maybe they are preserving it for their kids, because if they're in a life care community, they're going to be taken care of typically for the rest of their life. And they're not going to typically need that money that's in the trust, but they might still, the kids might take the money out and use it to make life better when mom and dad move up the ranks in the CCRC to assisted living or nursing.
Let's see. Okay, a follow-up to the question on long-term care insurance. Following up on the question, if you decide not to have long-term care insurance, how much money would you need? My mother-in-law had long-term care insurance, but it would not pay because the person who helped her was not an allowed helper. It has turned me off to long-term care insurance.
Yeah, kind of impossible to answer how much somebody would need. It's, that's why people do financial planning, and that's why I offer full service financial planning in addition to the estate planning and elder law, is to help people figure out how much they need in retirement, and it's different for everybody.
About the best thing you can do is just look at what the averages are, the average length of stay in a nursing facility, and then you kind of look at your own health needs. And if you're a very healthy person and no one's ever been in a nursing home and your entire family kind of drops dead suddenly at 95 behind the wheel of a car, you're going to go at it differently than if you have a different background.
Yeah, but getting some guidance from whether it be elder law, financial planner, aging life care, helping all that. It's one spoke in this big wheel of financial and legal planning. But I've heard her comment over the years quite a bit is that I've got this long-term care insurance policy, but my there's a lady down the street who does great elder care, and she's not a qualified provider. I have to pay her out of my checkbook instead of my long-term care policy. So thinking about that as well.
Mhm.
Some
Let's-
policies will cover an unskilled, untrained caregiver, but most policies don't.
Yep. All right. I've got our last question here. And whenever I say that, then three more are going to pop in. But Tawanda Young says, I have a patient who wants somebody to assist her with budgeting over her finance. Do you have any resources in Baltimore City that can assist with that? And I'm throwing that question out to the audience. If folks have some resources in the Baltimore City area that could help Tawanda's client, throw that out. But also, Evan and Elena, if you've got any resources that might be helpful, that would be great too.
Well, Elena's up in that area more.
Yeah, I've got somebody I use, and if somebody wants to get to me privately, just to send me an email, and I don't know if this person goes into Baltimore City, but she does travel. So
Great.
yeah, I might be
Yeah.
able to connect her with
I tell
somebody.
you, another profession that we should be doing these with is daily money managers, because I
Yeah.
think there's
I was going
they're
to
an
say.
important cog in the wheel. So I'm glad
Mhm.
that you threw that question out, because we can add that to the monthly series as well. Well, this is fantastic. And thank you guys. And thanks for going over the 1 o'clock hour. But in closing, I know that aging life care managers and elder law attorneys a lot of times work in lockstep. Do your practices, do you find there's a lot of synergy between the aging life care managers?
I use geriatric care managers, whatever you want to call them. I use them all the time, all the time. I'm not a clinician. I only know one part of it, and I couldn't survive without them.
Great.
Agreed.
Great. Well, this is great. Maybe we will remember how the TV shows used to do crossover episodes. Maybe we'll start doing some where it's elder law and aging life care on the same panel and see how that gets. But this has been great, guys. For a first time I was doing this panel, I think this format is wonderful, and it really speaks to the breadth and depth of your profession, but also, to the different practices and, different geographic areas. I've really learned a lot, and I hope the audience has as well. And I hope this was a benefit to the two of you as well.
Absolutely.
Well,
Pleasure.
thank you very, very much.
Great. Well, we'll see everybody. I'll send everybody a recording. You'll get a link to the podcast. You'll get contact info for Elena and Evan. And we'll see you next month, and we'll get to meet two new attorneys. All right. Thank
Okay.
you. Okay. Bye-bye.
Thank you.
Bye.